everyone. Today we welcome back attorney Annette Hines, who is joined by her husband, attorney Mark Worthington, to discuss disability benefits planning. Annette Hines is the founding partner of Special Needs Law Group of Massachusetts and has been practicing in the areas of special needs, elder law, and estate planning for over 20 years. Her clients include individuals and families of children with special needs, the elderly, and others in the community. She received her BA from the University of Vermont, her MBA from Suffolk University, and her JD from Howard University of Law. Ms. Hines brings personal experience with special needs to her practice as the mother of 2 daughters, one of whom passed away from mitochondrial disease in November of 2013. This deep personal understanding of special needs fuels her passion for quality special needs planning and drives her dedication to the practice. In April 2019, she published Butterflies and Second Chances, a beautiful memoir about her life raising her disabled daughter, which was an Amazon bestseller. I actually looked at that the other day after we talked about it. Recognized as a distinguished citizen by the ARC Massachusetts and cited for public service by both the Massachusetts State Senate and House of Representatives, Ms. Hines works tirelessly on behalf of people with disabilities. She is a member of the Mito Action Marcel's Way Family Fund Committee and was designated the 2016 Top Women of Law from Massachusetts Lawyers Weekly. She has been designated a Massachusetts super lawyer every year since 2014. Mark Worthington is senior counsel at Special Needs Law Group of Massachusetts. Mark is admitted to practice in Massachusetts and before the United States Supreme Court. He received his JD from Northeastern University School of Law and his LLM in taxation from Boston University Law School. He is a former professor and director of the graduate program in elder law and estate planning at Western New England University of Law, where he continues in adjunct status to teach courses in Medicaid, estate planning for retirement plans, and the grantor trust rules. Mark is a certified elder law attorney, a member of the Council of Advanced Practitioners of the National Academy of Elder Law Attorneys, past president of the Massachusetts chapter of the NAELA, vice chair of the NAELA tax section, technical editor of the Special Needs and Elder Care newsletter for Lamberg Information Services, a member of the editorial board of the NAELA Journal, and a trustee of the NAELA Foundation. He has been named a Massachusetts super lawyer every year since 2008. Is Martindale Hall AV rated, and has written and spoken for programs presented by the ABA, ALI, CLE, Suffolk University Law School, Pennsylvania State University, Dickinson School of Law, Stetson University College of Law, NAELA, and Massachusetts Continuing Legal Education. Mark wrote the issues brief NAELA submitted to Congress that preserve lifetime required minimum distributions for inherited retirement plans left to special needs trusts under the Secure Act. Please join me in welcoming Annette Hines and Mark Worthington.
Oh, my goodness. That was quite a lot. You know what?
Did we do all that?
You sure do. Thank you so
Next time.
much for being here.
Yeah, I'm sorry.
Next,
we should have shortened that up. I just sent them our usual blurb, and then
and
I didn't realize all that was going to get
We
read.
should tell you next time, please just tell them to refer to the brochure or something.
Yeah,
that is
sorry.
stuff only our mother wants to hear about.
Yeah, so we apologize. I'm sorry about that.
No worries.
Good Lord. Oh my goodness. Okay. So I cannot let today go by without saying wahoo that we are celebrating the 30th anniversary of the ADA, because on this day 30 years ago in 1990, then President George H.W. Bush, yes, signed the Americans with Disabilities Act into law. And I wanted to tell you a little story about a young 14-year-old girl in my town of Natick, Massachusetts, a small town, who rather dramatically really changed the world, actually. And it wasn't her mom that did it. It was she. Her name is Anjali Forber Pratt, and I am very lucky to know her and her family. She, in 1998, at the age of 14, and in a wheelchair, entered Natick High School. She did that 2 years after my daughter Elizabeth was born, who was also going to be wheelchair bound. She entered the town of Natick after the town of Natick's high school after extensive planning at middle school, and they knew that she was coming along. I know that yesterday there was quite a lot of sessions on transition planning and a lot of discussion about transition planning. And so you know how much work needs to go into planning for high school and planning for thereafter. So it won't be lost on you how little happened for Anjali. She gets to the high school and finds out that the classes that she needs to take, those are some advanced classes because she was a very bright young woman, were all on the second floor, almost all of them, and no way for her to get up there. She was shocked because she was told, her parents were told that, you know, don't worry, everything is going to be ready and waiting for you. So Anjali sued. Of course, she needed her parents' help to do that, but it was her idea to sue the town. And she knew that this really wasn't going to be for her because she knew, and her lawyers told her, that by the time this lawsuit wound its way, because by the way, our little town of Natick spent a fortune to fight her viciously. Viciously, they fought her. Rather than move those classes to the first floor, they fought this little girl viciously. And she won after a long time. She won compensatory and punitive damages. And she was the first one to be awarded punitive and compensatory damages under the ADA in a public education domain. First lawsuit. She knew that that was for others, not for her, because she was off to college by then. Anjali is an amazing woman. She was a Paralympic medalist athlete in the London Games. She is a professor at Vanderbilt University. She's brilliant. And I thank Anjali for standing up. This is 20 years ago now, 20 years ago. And she stood up for my daughter, Elizabeth, and all those who came after her, because we, very shortly after she won that lawsuit, built a new high school in Natick. And that high school has elevators, handicap accessible bathrooms, and compliant everything. So thank you, Anjali. And really, this is what it takes. This is what it takes. Because instead of planning for her, that one person that they could have done a good job for and thought through where her classes needed to be so she could have access, they had to go through this lawsuit and get smacked in the face. Okay. Thank you to everybody who came before. Now,
all right, now we're down to 1 minute per slide.
All right, first slide, Mark.
All right, this isn't legal advice. You're not our clients. Thank you.
Okay, so today we're going to talk about estate planning and why we do this kind of planning for ourselves and for our children. So, Mark?
Yes?
When asked this question, what do most people immediately think about?
Well, gee, I know, I can look at the slide and tell. Wills or estate taxes. And estate taxes, for most people in most states, are not an issue because the threshold has been raised so high. Most states don't have an independent estate tax. The federal estate tax exemption is now at $11.58 million and rises with inflation. So most people don't need to concern themselves with the state tax returns. And wills are just a tiny piece, and in fact, frequently a not very important piece of an estate plan.
Right. But rather some of the more important things we're going to talk about today. So why do we plan then? Well, we plan to have a really rather big say in what happens to ourselves, our loved ones, and our stuff, our assets, when we can't say. If we don't plan, here's what happens. Some judge in our local probate courts gets to say what happens. Things are going to happen according to law, not according to our wishes.
And that's even if you're not dead yet.
Right. So people who we don't want, or maybe who we don't even know, may be put in charge. Maybe some remote person in our family, or somebody who's estranged from us. Sometimes, you know, it's going to go by law, or sometimes assets are going to end up with people that we don't expect. Sometimes we've named a beneficiary on our life insurance policy and we've forgotten about it. Sometimes our life insurance or our retirement accounts are, if we haven't named a beneficiary, or if something is defunct, then they're going to go according to the rules of a contract, and we'll talk more about that. And sometimes we've lost opportunities for planning.
So the most common,
No,
the most common documents that we see, and you may know about some or all of these: wills, trusts of different kinds that can be irrevocable trusts, and revocable trusts, and the number of trusts. Saying a trust, that I have a trust, is like saying I have a vehicle. I haven't told you if I have a tricycle or a space shuttle or something in between. That's how different trusts can be. Powers of attorney and healthcare proxies and HIPAA authorizations, those three documents we tend to call, quote, incapacity documents. And then nominating guardians and conservators, either for yourself, should you ever need one, which we hope you don't if you do the other documents, or for minor children or adult disabled children.
Right. And when I was presenting on Friday, I got a lot of questions about planning for adult children. And I do want to touch on that a bit when we get to these documents today. So I know that when people initially start thinking about their planning, you know, I got to tell you, more than 50% of the time we get that call and people say, I need a will. I need a will. So of course you need a will. That's where almost everybody starts. So let's talk a little bit, Mark, about what is a will and what does a will do? Because that is kind of the starting point for everybody.
Sure. So it nominates somebody to stand in your shoes, which you can't really fill anymore because you're dead. To be sure the terms of the will are followed, and it can nominate guardians and conservators of minor or incapacitated children. In some states, we have a better way to do that. Like in Massachusetts, if your state has the Uniform Probate Code, you probably have a better way to do this than nominating in a will. Why a better way? Because if you become incapacitated, a will has no effect yet. If you become incapacitated and you need somebody to step in to be guardian of your child, we need another way to nominate them. The first bullet here specifies distributions, but distributions of what? The only things that a will controls are probate assets. These days, probate assets frequently are a small piece of your estate. Things that pass by contract, meaning life insurance and retirement plans, as long as somebody survives you who is named, that avoids probate. It does not go through probate at all. Jointly held assets, as long as your joint tenant survives you, doesn't go through probate. And any assets that you have title to trust, if you've done trust planning, also avoids probate. What's left? Stuff that you own all by yourself, in your name only, no other names, no passing by contract. It's just in your name, and when you die, it drops to the ground and nobody is holding it. That is what goes through probate and gets a new owner under the terms of your will if you have a will. If you don't have a will, then the legislature has an estate plan for you and says where the property goes.
So please don't worry if you don't understand all these terms, because we are going to start explaining and defining some of them for you. Also, if you start having questions as we go along, pop them into the Q&A or the chat, because we are going to save room at the end for Q&A. Plus, we're also going to be available for a whole hour for Q&A at noon. And we're happy to have you pop in then as well.
And that's good for Q&A for both today's talk and Annette's talk on Friday.
Right. Okay, so what is probate? Let's start talking about that in more detail so people can understand the importance of probate and also avoiding probate, because many people hear about, oh my God, I have to avoid probate. That's the most important thing. That is the most important planning objective that I have, because they hear about the horrors of probate.
Are you waiting for me?
Why, Mark? Why do people want to avoid probate?
Well, probate used to be a more difficult process, and it does seem to be kind of obnoxious to most people that somebody dies and now they don't have control over their spouse's assets or their parents' assets. But it really is, it's the least of the issues, because not because it doesn't matter, but because there's so many more important issues. And sometimes, as one of these bullets says here, there are some circumstances where we deliberately want a probate. There can be Medicaid planning reasons why we want that. And there can sometimes be issues where we want a probate because we know we're going to have issues that we want the court involved with.
We want the court oversight, yes. So really what matters is we want to make sure that we are setting goals and that we understand what those goals are. Then we're going to map to those goals so that we can get there. So we start with goals, and then we set a plan to reach those goals. We don't come in and say, hey, we have to avoid probate. Avoiding probate is not the goal. The goal might be, I want to take care of my family. So if you look at those cute little pictures along the left-hand side of those slides, the third one down, those two little girls that are the one on the left is grimacing, is my daughter Caroline when they were little. And the one on the right that's laughing hysterically is my disabled daughter Elizabeth, that passed away in my story that I talk about so often. Those are my goals. Those were my estate planning goals, to take care of my children. That's a goal, not avoiding probate. Now, avoiding probate might have been part of the planning tools that I used to take care of my children. There's a difference, okay? Next slide. Okay, so let's talk about what probate is so we can understand if we want to avoid it or not. So the probate process started really as a way to give notice to creditors. Right, Mark?
Yes.
So tell us more about that.
Well, all right. So look, you can read these slides as well as I can. But what I wanted to point out is, I mean, sure, it's notice to creditors, but it was also a way to ensure that assets passed to whom somebody actually wanted. And under the English law, this was kind of a bit of a departure from tradition where assets automatically passed to certain people by virtue of their relationship to you, sons or the oldest son or whatever the particular society might be. When you have freedom of disposition, as we do in English and American law, then the will becomes a lot more important. The process here, petition to have a will allowed, personal representative, yes, that's a probate thing. But inventorying and marshaling the assets, meaning kind of collecting them all up, and depending upon the state, giving notice to creditors, maybe, but probably not. Inventory and marshaling assets is true even if you're doing trust planning and you're having nothing passing through probate. Paying income and estate taxes, also true, even if you're avoiding probate. Paying debts of the decedent, maybe, maybe not. and making distributions to beneficiaries, that's true even if you're avoiding probate. And filing an account, maybe, if you're avoiding probate. If you're not avoiding probate, then it becomes much more important. So part of this process is, all of this process is true of probate. Some of it's true whether you're avoiding probate or not.
So one of the things that I guess people really just don't like about it is that it's this public process.
Yes, that's a big important issue. We've had people, beneficiaries, getting phone calls, and you need to let me help you invest your assets and all this kind of stuff.
And people
Why?
start getting mail sent to
because
them, and even the if people can see that there is a beneficiary with a disability or special needs, because they can see that there's a special needs trust involved, then they're worried about their individual who may be at risk. So there's a reason to perhaps plan with trusts, which are private. So as we start thinking about what is the goal, and I point back to my children, my goal is protection. Now I may want to be thinking about less going through the probate process, which is public, and more going through trust planning, which is private.
And
so what assets go through probate?
Well, we talked about this before, and just in the interest of time, would it be okay with you, Annette, if I move past this slide?
Sure.
Okay.
Because it's always easier to talk about what assets don't go through probate, because I think that's easier to discuss anyway. So
right.
next.
Okay.
Yes.
So then again, we've been through this a few minutes ago, so I just want to make sure that we can get through everything. But again, joint assets with a death beneficiary designation. Life estates is something that most of you will not run into during the course of your lifetimes, but I put it here for completeness. And assets owned by trust. So that's the stuff that avoids probate. And the reason is because the asset still has an owner when you die, either the joint owner or the person who's named to benefit under the contract, or trusts don't die. They just get new trustees. And there's an idea that trusts, oh, that's for really well-off people and stuff. It's not true anymore at all. There's so many purposes, and we've just talked about one, which is avoiding probate. Of course, that's only if the trusts are funded.
And privacy.
Privacy, yes. Sorry, we talked about that. Managing assets during life and even long after death. It's a great asset management tool. It is a superior tool to durable powers of attorney, although durable powers of attorney are still critical for certain assets like retirement plans.
Mm-hmm.
Protection of irresponsible or vulnerable beneficiaries from themselves. That is a huge deal. You can leave assets to people in a way that protects them from themselves. You can leave assets in a way that protects them from the rest of the world, from divorcing spouses, from they get into an auto accident and they're sued, or they get into a bad business partnership, and there's all kinds of things. Assets can be in trust, and it doesn't mean that that child is necessarily going to be giving up control. It depends on how you structure the trust. Estate tax reduction is sometimes still important, especially in certain states like Massachusetts, which still have an estate tax threshold of a mere $1 million. Obviously, this next to this bullet here that says planning for long-term care needs is a very important one for people attending this conference. Charitable intention sometimes, and then there's a lot more. Annette, do you want to add anything to this list before we move on?
Just that I see both the questions in the Q&A, and we're going to get to both of those questions. They're very good questions.
Okay. I'm having I can't really see them because I have to focus on our slide.
We'll talk about trustees in a few minutes.
Well, look at this. Look at the slide, trustees.
Yes.
Annette, I want you to talk to this one.
No, trustees were not one of the questions, but
okay, sorry.
So selecting trustees is probably the hardest thing that people need to do in their planning, because it can be very challenging depending on what kind of trust you are trying to fill that role for. And, you know, when you're talking about a special needs trust, it is really difficult because you can literally be selecting a role that is for an entire person's lifetime. And that goes on long after a parent is gone. So people naturally want to go to siblings, but it can be quite a burden. And managing a special needs trust is actually a complex. There's a lot going on there.
A lot of moving
you need
parts.
to understand distributions and public benefits and tax issues, and you know, it goes 10 steps further than just managing the average trust. And people will often say to me, well, you know, so and so Uncle Bob is really great with money and has done really well in the stock market. You can actually hire a money manager that, you know, can do a great job with the investments and finance, and you can hire a CPA to do a tax return. It's really more about managing the beneficiary that's the issue, and understanding the distribution end of things, and that's a lot more complex. So I think it's really great to do your homework and find out how you can support that trustee role more than anything. And there's a lot of literature out there about finding a good circle of care for your special needs adult child, because this is really what you're talking about. You're not really talking about your child, because fortunately most of you are going to be around for your child while they're a child, and it's really that carrying on for your adult child that you're thinking of. Next slide. Okay, revocable living trusts are how you are going to start organizing your thoughts to move from that public realm of you know, probate avoidance to, you know, privacy. And I think we can probably go through this really quickly, Mark, to get to the
I think
real
so. I
meat
mean,
of our.
we've already talked about a lot of this. Centralized asset management during life, that it's really superior to the power of attorney, and yet powers of attorney we need for certain things like qualified retirement plans and IRAs. I did note really quickly here a couple of estate tax things. The $11.58 million for the federal threshold. If you are $1 over that, each additional dollar gets taxed at 40%. The first 11.58 million is a freebie, but then it's going to snap back in 2026 to around a $6 million threshold. Most of us don't have to worry about that one either. But Massachusetts has one of the lower thresholds. I think there's about maybe 14 states or so that have an independent estate or inheritance tax, which are slightly different things. Massachusetts has an estate tax with a mere $1 million threshold.
So
yeah.
that is by example. Obviously, around the country, you're going to need to take a look, and given what is going on in our economy right now, and the spending that we're doing to try to shore up what is going on with unemployment and with COVID, you know, and no politicking at all here, there's gonna need to be some tax base to support the spending somehow. So whatever happens with the election, whatever happens over the next couple of years, we may need some estate taxes both on the state and federal level to support this. So we're gonna have to watch and see what happens.
Yeah, I think that there's a strong likelihood of the estate tax changing in a way that will tax more people going forward.
Yeah, so we'll just need to see, you know, what happens, and you'll need to just keep an eye on that with regard to your plan. And if your plan is drafted so that it's flexible and it bounces depending on what the estate tax is, that's great. Okay, next slide.
So, you know, the revocable trust, then it provides for succession of management, that is trustees, at least if it's drafted well. By the way, we spend a good deal of our practice with trusts coming in from the outside that, well, there's a lot of issues, let's put it that way. So if you have a revocable trust, it doesn't necessarily do all these things that it's supposed to, but it's very flexible. Basically, if you can dream it and it isn't impractical, it can be drafted. That partly depends upon your attorney's skill, of course. You can provide lifetime asset protection, divorce protection, public benefits protection for children, grandchildren, and so forth. And you can basically leave assets to others and eliminate estate taxes at each subsequent generation's death by having it, stay in this trust envelope, so to speak.
Yeah, don't forget about your other kids too. These are things we can do for your other children.
What a revocable trust doesn't do, and there's a lot of misconceptions about this, it does not provide asset protection for the person creating this trust. If you create a trust and you can benefit from it, or you can get the assets back on your own say-so, or even if the trustee can just give the assets back to you, even if you don't have any control, under most state law, that is yours, and it is not protected from creditors. There are certain states where it might be, but that's another issue.
Okay, Mark, we are really running late.
I know,
so
I've been trying to push you along, but you can protect against costs of long-term care, you can't protect against costs of long-term care for yourself. You can't save estate taxes for singles, and it doesn't affect your income taxes.
Okay, important. Powers of attorney, healthcare proxies, and HIPAA are the next things to talk about. So next slide. Powers of attorney for finance are very important to talk about. While a revocable living trust is great if you have moved assets into trust, that doesn't mean that you still don't need a durable power of attorney. And I got several questions about this for adult children. So I want to talk about how these can be used. So one of the drawbacks about powers of attorney are that financial institutions are really difficult to work with when it comes to powers of attorney. Why is that, Mark?
Well, they are worried that unlike a trustee where there's a trust and somebody's been appointed as a trustee, or there's documentation that they're a successor trustee, with the power of attorney, they're worried about liability, that the person named as the agent under the power of attorney is doing something that the principal, the person who created the power of attorney, doesn't want them to do. They will be looking sometimes, even if the power of attorney says that incapacity is not a requirement for the agent to be able to exercise power, they'll often be looking for evidence of incapacity. They will often be looking for, oh, this power of attorney is more than 3 months old. Get the principal to sign a new one so we know it's still good.
Right.
They're protecting themselves, and they're worried about liability.
And that's because it's a concurrent power, meaning that the principal, person who signed the power, is still in charge of all of their assets. And unlike, with a trust where the assets have actually changed title and ownership, in the case of a power of attorney, that's not true. The ownership is still in the name of the principal.
Mm-hmm.
So I still have my bank account, but I have given power of attorney to my husband, Mark. So he can actually go and empty out my bank account. Yes, as he does the Simon Legree evil hand move. And that's what makes banks so anxious. So the good news is this is great for parents who want to assist and support their adult children, but it is not good if your children are really at risk, because you can't undo mistakes that they're making. If they really, really are at risk of being taken advantage of, you really need to be thinking about authority where you are in charge and they are not. So you need some support from an attorney, a consult, to weigh the pros and cons of guardianship conservatorship versus incapacity documents like powers of attorney and healthcare agents.
Now, this is obviously for a child who has legal capacity of at least enough legal capacity to even execute these documents.
There are so many people who, if you can see my hands, have overlapping ability or overlapping capacity to sign documents, but also who have enough lack of capacity who could be under some form of limited guardianship conservatorship in almost every state in our country. So it's a tough, challenging state for all of us as parents to be in, and that's why getting a really good consultation from a talented, knowledgeable attorney can be helpful. And you may only need to go that one time just to talk it through. You may not need to, go back and spend thousands of dollars. But just to get assistance that one time to have that conversation. And that would be for you as the parent, not for your child to engage that attorney, okay? So the power of attorney for yourself is also very important, and every person over the age of 18 should have one. Okay. We also like to have a robust list. You want to have more than one or two if you can. But just remember,
one or two agents she's talking about.
Yes, one or two agents. Just remember that, these are people who you are giving access to, although it's not that easy. The banks are very, very nervous about this. Okay, next
now I want to
slide.
say just real quick, there's powers of attorney are extremely important too, because even if you have assets such that every one of them can be owned by trust, powers of attorney are important for other kinds of things too, like being able to deal with the Internal Revenue Service. If they come audit, somebody needs to be able to do that. So powers of attorney, extremely important.
Yes. Healthcare agents are a little bit easier because in many states it's a springing power. Mark, do you know, is that true everywhere?
I don't know of any state where it's not a springing power.
Okay. So your doctor's going to say when the power springs into effect, when somebody is not able to make their own decisions, and you're going to want to consult with an attorney, although every state has these, blank fill in the blank forms, and it can be a little dangerous to do that, although frankly, that's better than not having one at all. Okay, one thing I want to say about healthcare proxies for your kids, they're not effective for day-to-day decision making. I know many families who say, well, I had my kids sign a healthcare proxy form and they think that they're all set. Again, this is not, your kid signs the form and all of a sudden you're stepping into day-to-day decision making for your kid. First of all, it's not the same as being able to get and share medical information immediately. It only springs into effect when the doctor says that that person is no longer able to make informed decisions for themselves. And it is not really meant to immediately be put onto the person's medical record. So although there are times when that happens, this is not really meant for your 18-year-old. Okay, next. So HIPAA authorizations, a federal law, are for sharing medical information and not for decision making. And these are best when they are drafted by a knowledgeable attorney, although many places have their own medical records forms and medical information sharing forms as well. But when you can get a blanket form that you can share with all of your providers and put on the record, it is best to do that as well so that it complies with the federal law. Most places get these wrong, don't you think, Mark?
The consents that the like a hospital gives you is probably fine. Where they become often wrong actually is the ones that I see generated HIPAA authorizations by attorneys. So yeah.
Okay.
Let's keep moving because we're running out of time.
Yes. Let's skip over these things.
Okay.
We've got to get to trust.
You want to say if I should keep going?
Quickly. So if you're in a uniform probate code state like Massachusetts, you can appoint guardians for your minor children, and you can nominate guardians for your incapacitated adult children. And that means that you can have drafted, and you should do this with an attorney so that you are in conformance with your state law, a nomination. So you don't want to do this by will, because that's only going to take effect when you die. But you do want to do this in a separate document, and we do these all the time. And many of our brethren in our state bar don't do this, and I'm surprised by that. But it is a very effective tool, and you can even use this if one of the parents is a guardian and the other parent is a paid caregiver, for example. And it is a very effective tool to be able to have both parents participating in guardianship decision making when one parent cannot legally be on the guardianship record.
Now remember this,
they're a paid caregiver.
So this, we're talking about a private document that's a nomination. Only a court of law can appoint a guardian. So this is not some document where you're appointing a guardian. This is nominating for a judge's purview later if it's ever needed.
So you can do nominations and delegations. Nominations and delegations. Okay.
All right. Special needs trust.
So special needs trusts come in two flavors. They are third party and first party trusts, and how you sort of decipher which one you need is really, where's the money coming from? Is the money coming from the individual themselves, the disabled person, or is the money coming from a third party like the parents or grandparents, or some other gift that's coming in? Okay, next. So I think we all know that we're doing this planning to preserve assets for public benefits tests, but also because we want to manage assets for vulnerable beneficiaries as well. We don't always know that somebody's going to be getting public benefits that have an asset test, but especially third-party special needs trusts have amazing qualities to them. They are asset protected, creditor protected, all of those wonderful things that we talked about earlier. So and protection for divorce and protection from other threats. So we want to use them even when we don't have 100% assurance that somebody is going to be on public benefits for their entire life that have a $2,000 asset limit or whatever the asset limit is going to be. When you have a third-party special needs trust, virtually the only drawback is that the individual themselves cannot be the trustee. And for most of our folks, that is really not the drawback. That's not a drawback, because most of our people are not going to be managing their own money. Most of our people are just not going to do it. So it's just going to be rare that we're going to be worried about that. If the trust is drafted properly, and if somebody is not on public benefits, the trust can easily distribute money directly to them and can be used as a general support trust. It is not a big deal. And that brings me back to my original point about selecting a trustee who is sophisticated enough to know the difference and to understand how to make distributions, when to properly make distributions that qualify if somebody is on public benefits, and to do distributions that are regular support distributions if somebody is not on public benefits. It's a very challenging and demanding job, can be a very nerve-wracking job, can have some huge, huge ramifications if you don't do it well and don't do it right. So that can really keep somebody up at night and can make things very difficult for folks. Next slide. So what makes a special needs trust so special? And I'm going to wrap this up in a couple minutes so we can make sure we get to questions. Supplement but not supplant language And while that is not required, public benefits folks who review these trusts, like at Social Security or at your local Medicaid agency, are used to seeing it. So they really, really want to look at that, and they want to see that. Next.
But the language, well, I'll get to what should be and shouldn't be in a trust in a second, but go ahead.
The wholly discretionary standard, sole and absolute discretion of the trustee, should never say things like health, education, maintenance, and support, which is what people are used to seeing in a regular old, trust. Those standards, that's why we call it HEMS, H-E-M-S. That appears in many other kinds of trusts, and when people are not used to drafting special needs trusts, they will often put in those HEMS standards in a special needs trust by mistake. And so you might find that in a special needs trust. And if that is seen in a special needs trust, it may disqualify it. A spendthrift clause is something that needs to be in a special needs trust. Next. So a lot of people will come to me and say, hey, my kid's not on public benefits. I don't know if they're ever going to get public benefits, so I don't know if I need a special needs trust. I just answered that question by saying, but the trust can operate as a general support trust. The stigma of a special needs trust, well, we can call it something else. It's private, so most people are not going to know that somebody has a special needs trust, except for the people that are party to the trust. And frankly, our kids are really in the special needs world already. Trusts are expensive, difficult, and burdensome. A little bit, that's true. But the benefits far outweigh the difficulty and the expense of it, because you just gain so much by having it. Next slide. I'm gonna skip through this. Next slide. So these first party trusts are used to, if the disabled person has their own money, we can take that money and still qualify for public benefits. And the bad news about these, as compared to those third party trusts, are that we do have estate recovery or payback provisions. We can only establish them before age 65, establish and fund them. And we do have a limited number of people that can settle them or establish them. And that is the disabled person themselves, a parent, a grandparent, a legal guardian, or we have to do it by court order. It's rare that we don't have somebody that can do it, but very, very occasionally we do have to go to court to establish them. Next slide, Mark. Trustee responsibilities we've talked about. Next. We talked about this too. Next. Next. So what goes into a trust? Pretty much anything. Anything that you want can go into your trust. Mark's going to talk about retirement. We are going to run out of time. Go.
Well, do we have to drop it exactly 11, or do we get extra time because you got started late?
We don't. Go.
You can go a few minutes.
All right.
It's okay.
All right. So able accounts was a question that came up. So able accounts are not trusts, but they are super helpful because able accounts are beneficiary owned. That means the disabled person themselves can contribute up to $15,000 a year, or somebody else can contribute up to $15,000 a year. They do have some rules around them. You must have been disabled prior to age 26, but you don't have to prove it. You just have to certify it by saying, hey, the person was disabled prior to age 26. And if the person is working and has work income, they can contribute that work income over and above that $15,000. That means that if some money came in from an inheritance or a gift and it was a smaller amount, like not, you know, $200,000, but it was, you know, $10,000, you don't have to take on the expense of setting up a special needs trust. It does have that Medicaid payback, just like that self-settled trust that I mentioned. There are some practical obstacles in the day-to-day use because there's only one place to go in every state. It's not like you can set it up at any bank like a trust. In our state, in Massachusetts, it's Fidelity Investments. When you set it up, you have to set up a companion account and move the money between accounts. So very often the person needs either a guardian or a helper person, which they allow you to have, to assist with this. And then that guardian, that companion account, you can get a checkbook or a debit card to set up with it. But, you know, it is nice to be able to be beneficiary managed, which means that you can have some money in your own name and over the $2,000. So it is a tool in the toolkit of all of the things that you need to do. It's not a trust, and it's not going to satisfy all of the estate planning and special needs planning that you need to do, but it is probably a good way to help somebody start learning how to save when they need to maybe start working or start learning how to save for bigger items that that $2,000 asset limit wouldn't allow. Okay, next slide, Mark.
Okay, before I get into this, I really want to say one very important thing about supplemental needs trust, particularly third-party supplemental needs trust, where somebody's probably going to leave an inheritance for a child. You know, we've talked about the ways about what they can do and the way that they should be done. There's two things that can get in the way of that. First of all, we've seen a lot of third-party special needs trusts, supplemental needs trusts, that are drafted in an overly restrictive way. They may be good in terms of not being an available asset to the beneficiary, but unnecessarily restrictive. So the things that Annette was talking about, like, oh, if they're not disabled, you can use it for support and things like that. Some of these special needs trusts we've seen say it can only be distributed for certain these special needs and so on. That is totally not necessary. The second thing is that there are a number of states. You don't need to worry if all you care about is Social Security, SSI or something, but that's rarely the case. The thing about Medicaid is it's actually 50 state programs partially funded by the federal government. It's not a federal program per se. The states are supposed to comply with federal law. If they were complying with federal law, everything that we've said about special needs trusts, about third-party special needs trusts, would be true. But states routinely violate federal law in one way or another. Some states are much worse than others. You see Annette nodding. And
Yes.
so if you're in a state that violates federal law with respect to third-party or first-party special needs trusts, the things that we're telling you may not hold up. So you could be in a state where, for example, one of my students just the other day told me that where they practice in Pennsylvania, because I teach lawyers, not law students, and they said, well, in Pennsylvania, the third-party special needs trust has to be for the sole benefit of the special needs beneficiary. It can't be for the benefit of others. If that state was following the law, that would not be true. And of course, I haven't researched Pennsylvania law myself. Now, I just want to quickly, yeah.
Mark, 1 second.
Yeah.
Dr. Vockley said that he's gonna wait for us to finish because this is important and he wants us to finish our talk here. So he's gonna wait for us to finish here so the participants don't need to rush to get to the next section, okay?
Well, all right. So, I mean, honestly, I mean, if I didn't talk about secure at all, that would be the most important thing I think I had to say about special needs trust in this whole presentation. And that was nodding vigorously, so I think she agrees with me. That's a really important point.
So
you need to know not only about your state, but think about, is there another state where your beneficiary is likely to live their life at some point? So we have to look at it. Oftentimes when we're planning for our clients, we're looking, you know, like beyond that and say, well, might they end up in this other state over here? And we try to draft our trusts also with flexibility so that even though they are irrevocable trusts, There are amendment powers that can be used to adapt those trusts if we run into problems with various other state laws later on. Okay, shall I go on to secure, Annette?
Yes, and I think the most important thing to know is that if you already have some planning in place, it's highly likely that you are going to need to have it at least reviewed, if not revised, because of the changes in the law that went into effect in December.
And I will tell you this too. I've been practicing for 3 centuries now, a decade, whatever, something like that. And there have been exactly 2 times that I have needed to advise clients to come back and see me due to changes in law. Because if you're doing things well, you can draft trusts that can anticipate the known unknowns. And that's quite a bit. Most of the changes that people want come from that side of the conference room table. They have changes in their lives that they want to make changes in the plan. The 2 times when I have needed to advise clients to come back and see me, both times were where the federal law changed about how the law worked when a trust was named as the beneficiary of a retirement plan. First time was in 2002. Second time is right now with the Secure Act. So what happened?
One
Yes.
thing though, we are all about the free resources. And I know that this is all very, very fast, but we have a ton of free resources on our website. I have a podcast called Parenting Impossible, the Special Needs Survival Podcast. We have a YouTube channel where we have a webinar posted. Help yourself to all the free resources. We've got a blog post about the Secure Act. It's all out there so that all of you can, find out about it, understand it, and then go back to your own states, talk to your own attorneys, and you'll go to them with a good understanding of what you need to do. You'll be educated about it, and you'll have a good list, a checklist of all of the things that you need to do to address this. So go ahead.
All right. So the Secure Act went into law, but it was signed at the very end of December and was effective January 1 this year. It did a number of things that I'm not going to talk about, like it changed the age when minimum distributions need to start to 72 from 70 and a half. But what I really want to talk about is what happens when someone dies. What are the minimum distribution rules when somebody dies? Most of us are used to the idea that, oh, well, when I die, I name my kid or somebody like that as the beneficiary. They get to use the minimum distribution rules that say that if they want to, they can take out distributions from that retirement plan as slowly as over their life expectancy. And the big deal there is that if you do that, it's not just kicking the tax can down the road, so to speak. It's not merely deferring tax pain. By leaving assets in a retirement plan and taking them out as slowly as possible, the mathematics works out that you are actually getting more real net present value after tax money in the hands of the people you love than if they just had to take it all out when you died, even if we had a flat tax rate, which isn't true either. So now the rule in most cases is, sorry, you just got to take it all out within 10 years. You don't have to take out a 10th in the first year and a 9th in the next year and all that. It can all come out at the very end, but it's all got to be out within 10 years. There's 6 exceptions. The surviving spouse, and the surviving spouse still also has all the usual stuff about spousal rollovers and so on that the surviving spouse also always had. Minor children, but only until they're not minors anymore. As soon as they become adults, the 10-year rule kicks in for them. Then 2 categories which are of particular interest to us as special needs planners: the disabled and the chronically ill. I'm not going to, there's a lot of weird issues about those definitions.
Don't go into all that, Mark.
I'm not.
Get to the meat of it.
You're already slowing me down. And persons not more than 10 years younger. Now, the big one is this one, the Qualified Special Needs Trust. We got that in at the last minute somehow. I'm not quite sure how, except that it may have had something to do with a letter, an advisory opinion that was written, submitted by the National Academy of Elder Law Attorneys to the to the Congress over the summer of last year, and written by, well, somebody. Anyway.
By Mark.
So why this matters. Withdrawals from retirement plans are almost always 100% taxable ordinary income. That's traditional retirement plans, not Roths. Third-party trusts hit the maximum federal income tax rate of 37% at a mere roughly $13,000 of retained annual income. That is, if you haven't made distributions that distribute all the income. If you do make distributions, then that gets taxed not to the trust, but to the beneficiary, typically at a much lower tax rate. And it doesn't have to be cash, it can be buying things for them. So that counts as a distribution to them too for tax purposes. But if you buy an iPad for the beneficiary, that's not going to be something for most public benefits purposes that where the public benefits agency says, "Ooh, you got too much income." No, it's just an iPad. That's not income. Contrast with individuals which hit the top federal income tax bracket of $500,000 to $600,000. Now, whoops. So what I really wanted to point out is that if we can stretch the minimum distributions over the life expectancy of the beneficiary, now we have a much more manageable situation for the trustee to deal with in terms of managing tax, not having too much of the benefit for this child or loved one being taken away by the federal government in taxes and the state government, and not having all of this income just coming rocketing out of this plan within 10 years and paying most of it out in taxes, or almost all of it. Close to half.
The bottom line is, though, Mark, what they need to know is that you have to have certain language in your special needs trust that allows this stretch. Right.
So we've found, for example, that as much as we try to anticipate the known unknowns, this was an unknown. And most of our third-party special needs trusts need revision in order to take advantage of the Secure Act stretch for lifetime payout for special needs trusts.
That even for somebody with a little bit of retirement plans, it's a big help. Kyra, can I spend like 3 minutes on questions? Okay, so there's a couple of questions about POAs. I'm going to spend 3 minutes. They're such good questions. Somebody asked about, can I use a digital POA, meaning a copy? Yes, copies are acceptable. Copies of healthcare proxies and POAs, powers of attorney, are acceptable, and keep them on a flash drive. And we give actually little flash drives to everybody. So
you're going to need an original, though, in certain circumstances. Real estate in most states, you may need an original. Sometimes the government, like the Treasury Department, may need an original.
This one was asking about healthcare. So
I'm sorry, I thought you said powers of attorney. Yes.
Yeah, but they were asking about power of attorney for healthcare. So for finance, it's a little bit harder. They generally do want original, so you do need to keep the original around. Mental health care are very important, and generally every state has very specific rules around what they need, the language they need for mental health care. Springing means it only goes into effect in certain conditions, okay? So it springs into effect when something happens. It's not in effect upon signing necessarily, although the springing power might be the signing, but generally that's not it. What if your child is not technically disabled but needs help? So that is usually, we usually use those incapacity documents when somebody is not, has chronic conditions, and the disability, we still say, that's why we call things special needs or special healthcare needs, and we don't always label everything disability in our practice. Does the trust count towards the assets and so would remove them? No, that's why we use trust. The trusts, if they're properly drafted, do not count towards that asset limit. Also, same thing with ABLE accounts. don't count towards those asset limits. What happens if a vulnerable child has adult child has a sibling, but that person is not emotionally or intellectually up to being the trustee? Great question. If we expect the adult child's aunts and uncles to be around, who's left who could do this? That's why you need to sit and talk with an attorney or somebody in your circle that could help you walk through who's available. There are a number of possibilities for what we would call professional or corporate trustees. We have our own company that does this. There are people possibly in your state or in your circle that might be able to do this and step in as a successor and support to you in your circle of care. Okay.
I also just want to say quickly that you can draft trusts in a way that even if you're choosing the uncles and so forth that are unlikely to outlive your special needs child, trusts can be drafted in ways that can allow other flexibility. For example, like having trustees be able to choose successors even after you die, or having special trust protectors involved to do the same thing.
Okay. My adult daughter, is it correct that access to Medicaid or Medicare is a public benefit? It is, and therefore something all parents should consider when drafting a trust. It's huge to have health insurance, yes. And Medicaid is not just about health insurance, it's about access to all kinds of community benefits.
Yep.
Social Security is that trunk of the tree. Medicaid is, one of the other branches, and so many other things like housing and other community-based supports come as other branches off of that tree. Even when people don't need the health insurance and don't need the money supports, they still need other things that keep them independent in the community. So important. My adult daughter is on Medicaid. What happens to the money in a special needs trust when my daughter dies? Depends on the kind of trust. Is it a third-party trust or a first-party trust? Third-party trusts don't have payback. First-party trusts do. Can it be left to her siblings? And again, it depends. After payback, it can go wherever you want with a first-party trust. So if there is payback, then it may end up going back to the state or some of it, depending on the amount of the claim. But with a third-party trust, that's going wherever you want it to go. So planning is very important. Okay, and I think, thanks, I'll put our monthly disability benefits commonly allowable in most states for someone diagnosed with a metabolic disorder. That depends on how it's impacting their day-to-day life. I've had very good luck with this, depending on their need. So I think somebody raised a hand, and
we need to let this go for the next
yeah, we have to let this go. We will be in the Q&A session. I welcome you all back. It's been such a pleasure. Thank you so much for having us.
Thank you, Annette. We appreciate you guys so much. Don't forget you can join Annette and Mark in the Q&A session during the break. So I encourage you to do that.
See you at noon.
Thanks, everyone. Take care.
Bye.
Bye-bye.